the world is different than when I started practicing. The size of the giant companies, they don't need patents. I mean, Elon Musk said patents are for the weak.
Hello, I'm Bruce Berman, host of Understanding IP Matters, the acclaimed series that provides leading innovators and experts the space to share their IP story, the good, the bad, and the incredible. Wayne Stacy has a unique vantage point from where he sits near San Francisco Bay. As executive director of the renowned Berkeley Center for Law and Technology, he deals regularly with leading researchers, educators, entrepreneurs, and investors. He also speaks to many students. Wayne's interests include science, technology, intellectual property, and of course, artificial intelligence. Wayne had a successful career as a patent litigator at leading law firms representing clients from venture capital to Fortune 50. IP education has always been a passion. In 2020, he was named director of the Silicon Valley office of the USPTO. He received a Fulbright in 2024 to work with Nepal's leading law school and help design a legal curriculum focused on AI and data. Wayne, thanks for joining us today. It's good to see you again.
Well, Bruce, thank you for having me, and it's always good to see you.
Good. Okay, let's get right into it. Technology is a moving target. It's moving so fast right now, especially AI. What's trending today at universities and law schools? What are you seeing?
Well, I mean, the beautiful thing about Berkeley is it's at the heart of all of this. And AI, if you tell people here, the professors, that AI is new, they may throw things at you because they're like, no, we've been doing this for 30 years. But the emphasis and the involvement campus-wide has changed. So, you in the engineering school and data science school, you start seeing, more students being interested in it. So we've got this great robotics program, for example, that's linking AI and robotics. So you're starting to see these cross pieces. But I think campus-wide, you're seeing these initiatives to bring policy individuals, people from the law school and the engineering school together to talk about, hey, how do we look at regulating this in the future? How much regulation is necessary? Zero is not the answer.
Right.
And 100% is not the answer. But what is the answer? And Berkeley was kind of its unique position sitting in Silicon Valley, but as an outsider in many ways, and kind of looking at the public good, really pushes that debate forward. And it's great to listen to a lot of the campus discussions, the events we have for students and for academics, where you'll see people pile in to try to understand what the future looks like or what it should look like. And I think part of this comes from the recognition that the way the internet grew, out of the social media and how it all popped up. Well, Section 230 was no regulation basically, and it allowed a lot of things to happen and this huge growth. But now it could be part of the problem, and people are debating that and saying, well, okay, you've got to drive that growth, but when do you need to look at it and start evaluating, and how do you do it? So it's been a great discussion. I don't know if the answers are there yet, but if we don't have the discussion, nobody's ever going to have the answers.
That's right. And for future entrepreneurs, it's interesting because they have this need to move quickly and do incredible things, but also they're aware of the need to kind of manage that or rein it in somewhat, or at least project where it might go.
I work with a group that focuses on deep tech. It's a combined law school, engineering school, and Haas Business School. So all graduate level students. And it's great to see them start thinking about this. And one of the statements we always use is, if your business is regulation, or if your business is regulated, regulation is your business. And you've got to understand that you don't get to build everything you want to build. You need to pave the way and understand how to fit in. And a lot of times that's data usage. That's going to be AI usage. You're seeing in the robotics space. So it's great to get students into that mindset early on and have them start asking that question about, Well, where do I need to be involved? I'm an engineer, but where should I be involved on policy development? Because
Mm-hmm.
policy development is product development. They're kind of one and the same.
Mm-hmm.
If you get clipped, after spending millions and millions of dollars to develop a product, you've lost. So you need to make sure people know what you're building is thoughtful.
What's different today about preparing lawyers for practice than, say, a generation ago?
Well, I'm not going to even go a generation ago, Bruce. How about 5 years ago?
Okay.
I'm of a generation where I remember when, and I hate to say this, I feel like I'm getting old. The first law firm I worked at, they were complaining about their new networked computers, just in the office where there was a central storage facility rather than a local computer. They're like, well, that's going to ruin law. Well, people are just going to copy these briefs from somebody else. And then, of course, people are like, well, and then we make money by typing from original thoughts. And of course, very quickly it moved on. And we went from books to Westlaw and Lexis, so you could do more research. But the interesting thing is the price of litigation, the price of legal work hasn't gone down. Mm-hmm. What it's gotten is more robust. Mm-hmm. It's easier to file more documents now. And it's easier to produce more documents and search more documents. So the technology in some ways has always been part of it, but not a real driver of innovation in the industry. It's just allowed for more of the same, and in some ways, higher quality of the same for those that have access to it. I think AI is causing a different level of discussion because it can automate a lot of the lower end tasks. A lawyer charges $1,000 an hour. Well, that's a blended rate because some of their work is worth $1,500 an hour.
Right.
And
right.
part of it's worth $500 an hour because they're looking for periods and commas in a final brief. That's not really high-end legal work.
Right.
AI looks to take away some of the more mundane, more repetitive work. That's kind of the real change. And so the way it looks is it will enable attorneys to focus on the higher end work.
Right. So it's really redefining what is a lawyer today or what will be a lawyer in the future. Mm-hmm.
Very much so. And it may change the name, the game around leverage. So in other words, if I did insurance defense, well, I used to be able as a partner to manage 20 cases, over, this because they all look similar. Well, now I need to manage 100.
Right.
Because the briefings look the same and I can get updates and reports. And the concern of that, of course, is you don't need the entry-level lawyers, because that's kind of always my pitch is AI doesn't need to be perfect. It just needs to be a decent,
good enough, right?
Third-year lawyer. If it's a 75% third-year lawyer, I can use it as a partner. But what does that mean for entry-level people? And I think that means we need to scale up what they can do early on. And instead of having them be afraid of AI, and everybody talks about these hallucinations that pop up in the legal industry, what we're trying to teach is how to incorporate AI so they can have their own mentor from day one. I mean, if you've got the system that can look at all the cases and other briefs, it should be able to help me as a first year get a nutshell on this topic and say, what are the best defenses or what are the best offenses in this particular case, the best arguments. And then you just have to be smart enough and thoughtful enough, not just to cut and paste, but to look at them and say, this makes sense, this one doesn't make sense. So as a first year, you got to upscale quickly. And that's what we're trying to do is, instead of running away from the technology, really incorporate it so they can figure out how to use it early on. And, you don't have to wait for the partner to give you feedback on a brief. Maybe AI could be my colleague and give me feedback to begin with.
Yeah, well, the opportunity for apprenticeship, not just in law, but in many areas, is minimized with AI because that learning assistant editor in the entertainment world, in the film world. You don't need the assistant editor anymore, so you just need an editor. Or, for example, the high cost, Wayne, of and protracted timeline of patent litigation in particular is inconvenient to large corporations, for sure, for everyone. It's expensive. But it can be devastating to small and medium-sized businesses and independent inventors. What are some of the impacts, and what can we do about them?
This is the thing I've been yelling about for years. There are two parts to the patent system or any IP system. You need to be able to protect IP. I need to be able to file with the patent office and get a pretty good work product back from them and have a good idea of what my invention scope is. But you can have the best patents in the world if you can't get them into an enforcement system. The system doesn't work. And I think that's where the U.S. is broken right now. The patent litigation's gotten so expensive. I mean, a lawyer at my level now would be over $2,000 an hour.
Wow.
And you don't litigate by yourself. You're litigating with a huge team. You're looking at millions and millions of dollars. To give you a number, we were listening to a recent conference, and one of the law firms, high-end law firms that does enforcement work on contingency, and one of the big investors, the funders, said that they're looking for cases that have a minimum of $100 million return. That's all they can afford to invest in anymore because they're expecting to spend 20 to 25 million. And so they need 4, 5, 6x return. So think about that for a minute. You can't even go to a litigation funder unless you have a $100 million case.
How many of those cases are actually paid? There are some multi-$100 million cases, but often they're not paid in the long run.
Well, in emerging companies that are getting into a space and that need to, they've got great innovation, but they need to stop somebody from copying, that's where it's really hard. So if your entire market is only $100 million, that's a great small business. I mean, that's a great small business. It can really generate a lot of jobs, but your patents can't support you. And I think that is to me, the number one threat in the way our litigation system has developed with heavy discovery, kind of running damages and invalidity and infringement all at the same time. The costs have gotten out of control. And then the problem is your end game is uncertain. Damages now are highly suspect. You talk to a lot of experts, they don't know really what to put together anymore because the Federal Circuit keeps changing the game. And they get overturned. Not just the $1 billion judgments get overturned, but now there are $20 million judgments, $30 million judgments. You tie all that together with taking 5 years, no injunction. It's really devastating. And, I'd have to question as a U.S. innovator what a patent really gives me, except maybe a chance to sell my company to a bigger company. It's always that fear of, hey, if they put me out of business, well, then I can sue them after I'm out of business. But I worry about the costs, not letting kind of small, medium enterprises generate jobs and move forward to being a bigger business.
Right.
So,
and innovation, when patents can't be enforced or readily or litigated for infringement, it not just, it looks good on the surface, like, well, no one's wasting money and, companies deep-pocketed companies aren't being targeted, but it also kind of dilutes the DNA of innovation. If truly disruptive, important inventions get pushed aside because they can't be protected, that's not good either.
Yes and no, Bruce. I tell you where I absolutely agree. That 100% applies to the small and medium enterprise world.
Right.
The world is different than when I started practicing. The size of the giant companies, they don't need patents. I mean, Elon Musk said patents are for the weak.
That's right.
And he is
They have
right.
brand. They have brand. That brand is everything in a way.
Brand, uh, manufacturing contracts, commercial relationships. They just have this whole ecosystem that prevents people from copying their products. Look, if you gave me the blueprint for the most recent iPhone, great. What can I do with it?
Right, right.
I don't have iTunes. I don't have Apple Music. I don't have everything else. I don't have the manufacturing contacts. It can't be done. So the size of the giants kind of make patents irrelevant for them, though they still get a lot of patents.
Sure.
But they don't need them for competition broadly. Right. They maybe against each other, Apple,
right.
Samsung.
Right.
But I just don't know what the real value is to small, medium enterprises with the way our system has developed. And so that's where I quarrel with you a little bit. For them, it affects the innovation system 100%.
There's legislation now in Congress for stronger patents and to kind of restore the system to where it was, where, you could actually, license on business terms, fair and reasonable kind of terms, or litigate if you had to and actually win. Should we go back to an era and a configuration like that, or is that impossible now that we're onto other technologies? Software doesn't necessarily require patents or is patentable.
And those things will adjust about individual technology areas. Originally patents for around software were difficult because there was no prior art. I mean, I was there when that whole world changed, and the prior art was horrible because no one was publishing anything. There were no patents, and it settled down. The U.S. has also professionalized the patent office. They used to, 25 years ago, examiners were wildly underpaid, I think horribly mistreated. And now it's a real professional organization. And it's hard to complain about the work that the examining corps does, kind of against that target of what they're asked to do. They're not asked to be perfect. They're asked to be efficient and good enough for the price to get the patent system, a patent started.
Right.
I think there is a way to go back. Look, I'm a big believer that the injunction is a powerful tool. And there's legislation on that. And I'm going to say the injunction, but I'm going to qualify that by saying a properly written injunction. Mm-hmm. And it used to be, and you see this in Europe, but in the U.S., when injunctions were put out there, the judges were a little bit lazy, or maybe a whole lot lazy. They just said, hey, stop selling that product. This idea of apportionment, about looking for the smallest saleable unit or something like that, never worked its way effectively into the injunction world. Mm-hmm. So the injunctions were a bigger hammer than they should have been.
Right. It's a blanket kind of thing. Stop all production, or whatever. Mm-hmm.
The judges always have the power to be equitable and kind. It's not really kind. It's equitable. Hey, you didn't know about this patent, or you were sued. You had a good faith defense. You made a bunch of watches. Well, we're going to let you sell those watches. You're going to have to pay a royalty, but you can't sell any more of them with that feature.
Right. Mm-hmm.
And that way you don't get caught with $25-30 million worth of product sitting in a container. That's not good for anybody. So, I'm a big believer that the injunction should be restored as the primary right, with some guidance from Congress that the injunction should be focused on the exact infringing component, along with equitable remedies for, hey, you didn't know about the patent, or if you did know about it and it's a willful issue, well, then you get no relief at all. Sorry, you tried to make all those watches and sneak them in. You're not bringing them in.
Wayne, this year, or in 2025, I should say, you were at Dolby Labs. You spoke across the bay at the Dolby headquarters in San Francisco. And you said that you see students pursuing patents without realizing what having them really means. What did you mean by that?
Broadly, look, innovators, not just students, any kind of entrepreneur that's learning about patents, kind of hears about it in cycles. You don't learn the whole scope at once. So you just learn about acquiring it. And if you read the textbooks, what do they say? Well, if you get a patent, you've got the right to exclude others. And that's where they go. Okay, I got to get a patent. Understanding the litigation enforcement licensing end is a lot, not only for students, but for innovators.
For innovators. It's 100% of something, I like to say, but usually the 100% is of nothing.
Very likely can be. And that's the trouble, is people don't understand what does the patent really mean. And I think shows like Shark Tank have been
terrible.
Yeah, they're like, oh, do you have a patent?
Yes.
And I mean, I'm slow to ever criticize someone like Cuban who's had such great success, but he always asks that. And I've always wanted to ask him, why? How does that impact your decision? Are you just checking diligence, or do you see them actually enforcing that patent? Is that a license issue?
Right. No, that's a really good point. And it reinforces the notion that a patent means so much. And it can mean a lot, but most of the time it doesn't mean as much as people think it does.
I'd say most of the time, outside of the pharmaceutical industry, and they've got lots of lawyers.
That's right. It's it's more of a one-to-one relationship between a formula and a particular patent. And Cuban in particular, he's not a fan of patents traditionally. So it's kind of interesting.
I think he understands. Well, I'm just assuming, with his business background, he understands what you can do with patents, but he commonly asks that question, how are you protecting? And, I've debated this or discussed this, I don't know if it's a debate with others, like, I wonder why he asked that question. What does that tell him about the company? Because, he's not going to put a $10 million in to litigate the patent. So if somebody said, I've got a patent and I'm going to sue my innovators, I'm pretty sure I know what all the sharks would be saying is, we're out.
We're out. Yeah. Sometimes, it's funny. I know someone in licensing, and he says sometimes this is more product, like household appliance and other kind of licensing, which are covered by patents, design and other, and utility patents. But he says people come and they want to wave a patent in front of a potential distributor or partner, and they think that's going to be great, and they're going to say, okay, we want to talk to these guys, but it's the opposite. They don't want to have anything to do with you. You have the patent, you think you're going to use it, you can't use it, and you have a starry-eyed notion of what the market is. It's not really always about the patent, having a patent.
I'm with your colleague on that. Leading with a patent is a bad idea, and I go back to a client I had many years ago that had incredible technology, but they were too small to roll it out at the scale this customer wanted. And the customer said, we love this, but we're going to work with one of these giants to build it ourselves. And I had to get involved at that point in time. Like, well, when you do that, we're out of business, and that means we've got this patent portfolio, so we've got to make money one way or the other. Would you find an alternative to that? So it wasn't a threat, but it was a clear indication that if you put us out of business, now we become an enforcement entity.
Right, that's right.
And we handled it gently, and the company on the other side then went to the giant and had them buy us. And it made perfect sense for everybody. They had the scale, we had the technology, and I was like, that's the way the system's supposed to work. They saw it, they liked the technology, but they needed it at a larger scale. They needed somebody that could service it, guarantee 99.99% uptime. And we weren't going to be able to get there. Just the scale, the amount of capital was outrageous. And the deal worked perfectly. I'm like, that's the way patents are supposed to work. But they were at the end of the discussion, not the front.
Do IP rights, Wayne, still make sense in areas like software, e-commerce, AI? The young companies don't seem to really covet patents in that area. They feel, do we really need them? How can we enforce them? What are they going to mean? We can't license. Are you seeing something like that, or?
I hear the discussion a lot, and my disposition is I'm concerned about the value of patents. And again, I spent my life enforcing patents on the innovator side. So I'm not one of the lawyers that spent all their life defending. I spent most of my hours of my life on the innovator side, and it hurts me to say that I'm worried about the value of patents. But every time I say I worry about the value, I'm also cognizant when you look at Meta, Google, they're building huge portfolios,
Mm-hmm.
but they do them for a different purpose.
That's right.
They're not suing on individual patents. So I'm not ready to walk away from them in these areas, especially these innovative areas that lots of R&D dollars are going into.
Mm-hmm.
I'm a little more skeptical around apps and some of the fast-moving software. Unless you've really got something special, I don't see the value. But in the build out for a lot of IP or a lot of AI, there could be some really interesting things going on. But I don't know if those are going to carry forward to everybody that tries to take an AI engine and automate something. I want to build an AI doc.
Mm-hmm.
Well, that's a different issue than building the AI engine and controlling that. Though I
Right.
do think what we're really seeing is the rise in trade secret litigation, trade secret protection.
Yeah,
And
that's a
that,
big deal now. Yes,
yeah.
it's really evolving, and that's good and bad. Some people say trade secrets, it discourages, sharing, and you look at things quite differently with trade secrets. But it might with data. Well, we can get into that later. It's data protected under trade secret. We don't. It's not clear. Berkeley, as a university, has a long tradition of innovation and breakthrough work. I think it's number 2 rated by U.S. News and World Report, or the IP part of the law school, which is amazing, second only to Stanford, which has a little different philosophy, as we know. And it's produced many leading scientists, entrepreneurs, Nobel laureates. Yet some law school faculty, not just at Berkeley, but other places, they tend to be dubious about strong patents and copyrights. How does that happen? And what's your thoughts about that?
So I think it's fantastic to have that debate.
Mm-hmm.
So if you look at Berkeley, it's the thing I really enjoy here. Before I do that, just make sure, depending on what you're reading, Berkeley's number 1 and Stanford's number 2. So
Okay. Okay.
just so you know, but there is a different approach. But I think the sheer size of the center here is very different.
Mm-hmm.
I've got, I think, 24 professors that are faculty co-directors. Most centers at other schools have 2. And so they take on a personality of the 1 or 2. Here, the center has no personality because we have competing views on copyright, on patent protection, and that generates a really thoughtful debate. So we have people that would be copy left, people that would be copyright. In the patent space, we have people that would be, harsh on the pharmaceutical industry and around the IP protection there, and those that are very supportive. And when you start working together, you actually can start finding the overlap. Well, unless people are incredibly extreme, and we don't have those levels of extremeness because their colleague can help balance things out. Mm-hmm. And so we have a professor that's probably harsher on the pharmaceutical industry than our other professors. But when you really dig in, you start finding it's not the attack on patents, but an attack on some of the practices used to extend time periods using patents.
Yes, yeah.
And no, that should be a debate we all have and look at and say, wait a minute, Is this what Congress intended?
Right.
This extra 7 years kind of tacking on at the end
for the delayed response pharmaceutical, because it stays in your body 24 hours instead of 4 hours. Right. They get another patent. Yeah, it's a bit questionable. I've spoken to law school professors, pretty prominent, eminent ones, and they say, I don't know how IP is taught here, but it's not very positively taught. And you wonder how it gets that way and what the next generation of lawyers is going to think, because they're not exposed in a way that is necessarily, pro IP in some cases. Yeah.
I definitely worry. We bring in kind of on a regular cycle a director for life sciences.
Right.
And the goal is to bring in, newer attorneys that have real interest in any kind of the pharmaceutical, life sciences world, and introduce them into the academy. So we bring them in and hopefully get them a job going out. And the goal is to present this kind of balance that we have at Berkeley. And in any one person that says they're balanced, I'm always skeptical of. Everybody's got bias on one side or the other. But if you can put 3 or 4 people together and then all their perspectives generate something new,
right,
that's what I love.
And if they can respect one another too, that's important.
And it's good when they're in the same institution because they have to see each other in the halls. But
yes.
But what I did see, with this life sciences director position, there are definitely some law schools that very much were in the life sciences space of patents kill, and did not want to even talk to a junior professor about, hiring them if their publications weren't in line with patents kill. So they've got 1 or 2 professors that teach their IP that are hardcore on that side and want no debate within their school, and deliberately put their thumb on the hiring scale. So they're absolutely squashing academic freedom. And they're the people that say, I love academic freedom. But at the same time, what they're saying is, I love academic freedom, and so I select people that agree with me.
Right.
And with Berkeley's kind of larger group, you can't do that. And I think the schools that are most in danger of introducing particular attitudes are those that have smaller programs, 1 or 2 people that are, that are jockeying for positions on publications and want to be the loudest voice on a particular issue. Causes problems.
Yeah. Wayne, we're getting towards the end of our time. So I wanted to ask you about, you joined the USPTO as director in the Silicon Valley office. I think it was in 2020. What was that experience like? What led to it, and what was it like?
So, I came in under Andre Iancu. I loved Andre's approach and what he was saying about, we have to protect innovation. And there has to be balance. And if you look at his career, he'd done patent litigation for innovators and for, accused infringers. He was balanced because he'd seen it all. So I'm like, I want to be part of that. I was kind of in a good place in my career to step out, go to government for a few years, and thinking about just coming back to practice law again. So went in on that front, and then COVID hit, so it kind of made it a little bit challenging. But it also was really interesting for me because everything was done by Zoom. So distance from Silicon Valley to DC made no difference. We were all the same. And so I got to know people in a way that the geography did not hamper. And really, really loved that. So I got to be part of that push forward. And really, Deputy Director Peters with Director Iancu, I thought they really were thoughtful about what they were trying to do with the regional offices, which, by the way, have no definition. It's what every director kind of thinks about what they're going to do with them. And, Andre was using it and Laura was using it to improve the operations of the patent system and to make sure that voices were being heard that didn't have lobbyists in Washington. And so I love the fact that they let me come in immediately and start building a dashboard to track who we were talking to from the regional offices. Because one thing I noticed was that DC, anytime they flew out to see somebody, well, they loved to fly to Eugene, Oregon to see Nike. They loved to fly to Hollywood. Nobody went to Sacramento. Nobody went to UC Davis to understand what's innovation in the ag industry look like. So with Andre and Laura, we helped build this dashboard so we could see who are we talking to and where are they located based on their innovation. And I really, really loved that process. But of course, with the next director, things changed. In the regional offices, I don't think are a useful thing unless they have a defined purpose. And I think that's now why they've been effectively eliminated in any meaningful capacity. You saw the Denver office shut down. It's now in Montana.
Yeah, they talked about a Montana office recently.
But it's an outreach office. I reported directly to the deputy director. Now there's layers between the regional offices and the deputy director. I talked directly with Commissioner of Patents about here's what we're learning from people. Now there's filters. I don't think the regional offices ever will be that effective other than window dressing unless there's some consistency about what they're supposed to do. And there's so much pushback from Washington on giving up any power that I don't think they'll be able to do much. And that's sad because there's a long ways, both physically and mentally, between what happens in Washington, D.C. and what happens in Silicon Valley. And the stories that you get in Washington, D.C. are from those that have the lobbyists that can walk the halls.
Right.
Not from the small, medium enterprises.
Sure. You received a Fulbright to work in Nepal in 24. That must have been an incredible experience. So what were you doing in Nepal with IP and AI there?
It was a spectacular experience. So they were looking at how do they teach? So it's a faculty of law that oversees the teaching for the entire country, for their primary public institution. And the goal was to help them understand what they could be teaching going forward and how they prepared their next generation of lawyers, because their next generation of lawyers also turn out to be their next generation of cabinet ministers. There's a close tie. And so if you're dealing not just their base lawyers, but their lawyers getting their master's degrees and their PhDs. So how do you blend in this kind of developing economy that's squeezed between India and China on approaches? How do you help, preserve local culture, but blend them into the world? And, Nepal's always had this close tie with the English-speaking world for education. The U.S. helped build out that system in the 50s, and they just have a different relationship with us on that front. But our models don't fit perfectly, so we had the opportunity to look and build out a really comparative curriculum to help them understand, here are the options that are happening around the world. Here's what's working, here's what's not working. And then using their local professors to figure out how to blend that together. Challenging.
This has been great, Wayne. Really, thanks so much. Final question, we'd like to ask on Understanding IP Matters, what was your first encounter with IP rights?
First encounter was the encounter that drove my entire career. On the side of I grew up farming and ranching in the panhandle of Texas. Dad was a farmer, grandfather, my great-grandfather. I remember seeing in the block of an engine, of a tractor engine, it had, in the cast, so not one of those little tin things that was riveted on. In the cast, it had a patent number. And that got me interested in it as probably a 13-year-old kid. And, isolated farm town, I wanted to do something else besides farming growing up, or when I grew up. I loved farming. I loved what I did with my dad. But I'm like, that's interesting. That took me to engineering school. I went to engineering school with the idea of being a patent lawyer because I read about that. I saw that, and then I did research on it, read about it. I remember having to look it up in an encyclopedia. My son doesn't know what that is anymore.
No. Those are gone.
So that's what got me there. I loved science. I loved engineering. I loved math. And probably in the era of LA law, I'm like, I can be LA law plus patents. That's what I wanted to do. A naive dream for a 13-year-old kid in a farm community. It's kind of silly looking back on it, but I chased it.
Very American dream. I like it. Thanks for being with us today. This is great. I hope you'll be able to join us again this year. We're going to be in Columbus for the IP Awareness Summit at the Center of Science and Industry, a really exciting place. And I hope you can join us again.
I look forward to it. It's always great.
Okay. Great. That's April 23rd. But for now, this is wonderful. We'll have to have you back on. There's still so much more we can discuss, but that'll be, down the road.
Wonderful. I appreciate it, Bruce.
Hello, I'm Bruce Berman, the host of Understanding IP Matters, the critically acclaimed series that provides leading innovators and experts the space to share their IP story, the good, the bad, and the incredible. Understanding IP Matters is brought to you by the nonprofit Center for Intellectual Property Understanding, with the generous support of its partners and sponsors. Subscribe on the platform of your choice or email us at explore@understandingip.org. Content provided is for informational purposes only and does not represent the views of CIPU or its affiliates. This episode was produced for CIPU by Podsonic. Thank you for listening.